Madhusudan Sharma ji to initiate discussion on the proposed amendments in the voluntary liquidation process. He is an IP and a uh, practicing advocate having 40 years of experience.
Thank you, Anchal. Welcome to all the participants and special welcome to the speakers, Mr. Amit Sharma, Sudhaji, and Pranavji, who will share their experiences on voluntary liquidation process. Now, today's webinar will be in two parts. The first part will be regarding discussion on IBBI's paper, which is proposing some amendments in the voluntary liquidation process regarding its withdrawal. The second part will be sharing of experiences relating to voluntary liquidation by some of our members who have handled number of cases. So coming to the first part of it regarding the proposed amendments in the voluntary liquidation regulations. Like there was no provision for withdrawal of CIRP process once it was admitted. Similarly, there is no provision in the voluntary liquidation to call it back or withdraw. And incidentally, it happened in my case, and probably that was the first case of withdrawal of voluntary liquidation, that the company passed a special resolution and told that now no more we want to go ahead with the voluntary liquidation, and this process is over. And that point of time, nobody was clear. I referred the matter to IBBI, but IBBI didn't have any response immediately on that because everybody was taken aback that could there be a situation in voluntary liquidation when the company would like to withdraw it for some reason or the other reason. And the company which withdrew this voluntary liquidation took opinion from the ex-chairman of the company board, who opined that since in the voluntary liquidation the powers of directors are not suspended, they can call for an AGM and they can reverse the process because it is a voluntary process and it is for the shareholders to decide whether they want to continue with it or not. And that's how it was withdrawn. And as per the IBBI's discussion paper, there are 8 such cases where the voluntary liquidation has been withdrawn. My case happened way back in September 2018. So it is almost 2 years now that IBBI has thought of this provision. And it's a welcome thought in terms of the amendment so that it will bring clarity into the process of voluntary liquidation. So out of the 8 voluntary liquidation cases which have been withdrawn so far, 5 are by way of special resolution again passed by the shareholders of the company to withdraw it. And in 3 cases, it has been through the adjudicating authority. One was the liquidator approached because the company was not solvent. And in 2 cases, the company itself approached for withdrawing this process. So existing provision of voluntary liquidation is in Regulation 39, which talks of only 2 conditions when the voluntary liquidation can be withdrawn. And an application can be made by the liquidator. That is either if it is being done to defraud the creditors, or the second option is when the company is not solvent, because one of the prerequisites of voluntary liquidation is that the company should be solvent. It should be in a position to pay all its creditors. So if it is not so, then the liquidator can approach. Now in this background, IBBI has proposed certain changes and ask the opinion of the people at large. So I would like to share that for your ready reference, so that before we invite opinion from the members, then it will be very useful. So what IBBI is proposing, I'll first discuss that and then the questions. The IBBI is proposing that the withdrawal can be allowed if there is a special resolution being passed by the members of the board. And there are 2 situations which IBBI is discussing, is that when there is no process of sale initiated or when the process of sale is initiated. So this is the proposed amendment, which talks about that where the process of sale of assets of the corporate debtor has not been initiated, the members, partners, or the contributors, as the case may be, of the corporate debtor person may resolve to withdraw from the process by passing a special resolution with a special majority, provided that where the corporate person owes any debt to any person, creditors representing two-thirds in value of the debt of the corporate person shall approve the resolution process passed under sub-regulation within 7 days of such resolution. So that is similar to what the process was to start, that you have to take approval of the each shareholders with a special resolution and approval of the creditors by two-third majority. So the same process has to be repeated for withdrawal. The second regulation is that for the process other than the mentioned in the regulation 1, members, partners, or contributors, as the case may be, of the corporate person may resolve to withdraw from the process by passing a special resolution with a special majority after the said resolution is either approved by all unpaid creditors or due of all unpaid creditors have been settled. So second situation is that where sale has started, then the approval has to be for all the outstanding debts. In first case, it is only for the two-third majority. So that is the proposed amendment. Now, IBBI has asked opinion of the members on the 4 questions. These are: should there be a provision for withdrawal of voluntary liquidation process if such withdrawal is approved by special resolution of members, partners, or contributories, as the case may be? If so, if yes, then whether such withdrawal is to be approved by AA or it could be within the domain of the company by passing a special resolution. The third question is this: should the withdrawal be permitted both prior to and post initiation of process of sale of assets of the corporate person by the liquidator? The fourth question is, if so, what conditions should be imposed to ensure proper checks and balances on such withdrawal? So there are 4 key issues. First, whether voluntary liquidation should be allowed to be withdrawn by passing a special resolution by the company. Second thing is, if it is to be allowed, whether it should be approved by the adjudicating authority or there is no approval of adjudicating authority required. And the third thing is regarding at what stage that withdrawal process is, depending on what checks and balances should be done, whether it should be allowed, if allowed, what checks and balances should be done. Like some of the checks required is that special resolution by the company plus approval by either two-thirds of creditors or 100% creditors. So these are the questions which IBBI is asking opinion. Apart from that, if the members have some more opinion or observations or suggestions, they are welcome to suggest, so that we can compile all these suggestions and send to IBBI for their consideration. So to initiate this discussion, I'll first invite Mr. Amit Sharma to share his opinion on all these 4 questions, plus anything else which he would like to suggest. So Amit ji.
Hello,
हाँ अमित जी.
am I audible, Mr. Sharma?
Yes, you are audible.
Okay.
Should I keep these questions displayed or?
Yeah, that will help.
That will help. Okay, that is better.
And I don't know whether my video is on or not because it is not showing here.
Now it is on.
Okay. First of all, good evening to everybody. As Mr. Madhusudhan Sharma has pointed out, that there had been certain instances wherein adjudicating authority.
Amit ji, we are missing your voice.
Sorry for the disturbance.
Yeah.
They have come across certain instances wherein voluntary liquidation had been requested to be withdrawn. Now, to my mind, the voluntary liquidation process is a well thought out process. It's a well thought out decision taken out by all the stakeholders involved in a company, like the management of the company, the shareholders and creditors. The board of directors have taken a conscious decision to go into voluntary liquidation after having uh, uh, given a good thought over the audited balance sheets of the company for the last 2 years. They have perused the valuation reports before taking that decision, and after giving a good thought over it, they have decided that they should go for a voluntary liquidation. Subsequent to that board resolution, the resolution has also been passed by the special resolution of shareholders. So they have also contributed to the decision of management. And after that, if there are creditors, two-thirds majority of the creditors have decided that company should be voluntarily liquidated. So the decision was a well thought out decision, and everybody had contributed into that decision. Subsequent to that decision, now we can we can think of possible three situations as to why a company would be willing to go into voluntary liquidation. First and foremost is if the purpose of the company has been over by virtue of any clause mentioned in article or memorandum of association of the company. Secondly, company is the management has decided, that is the another point. And the third one is that the company thinks that they have adequate assets to meet out their obligations, and now they do not see any possibility or any reason to continue with the operations of the company. So if we give a combined view to both of these situations, it can be safely assumed that the voluntary liquidation process is a process which has been taken after giving a long thought of the on the prospects, on the present, and on the past, and on the future of the company. So they have come up with a decision. Secondly, the board of directors at the time of deciding the voluntary liquidation of the company, they have to give a undertaking that the company is having adequate assets, the company is solvent, and they are not going ahead with the voluntary liquidation with an intention to defraud any of the stakeholder. So these are the backgrounds on the basis of which a decision is taken. And now we uh, if we correlate the provisions with the liquidation process, as it has been mentioned in the voluntary liquidation regulations itself, apart from the initial process of voluntary liquidation, the entire process is more or less same with the as that of a liquidation process initiated by adjudicating authority. Now, if we talk about the reasons as to why a voluntary liquidation process is required to be reversed, why would a management, after having taken a decision to voluntarily liquidate the company, would be willing to come back to reverse its decision? And in this, when we give a thought to it, possibly there are 2 or 3 reasons which are prominent. First, either the liquidator is come up with a opinion that there is a fraudulent intention of the management to voluntarily liquidate the company. B, the company is not solvent, the assets are not adequate to meet the liabilities or the debts of the company. And C, the management or the company is now seeing certain opportunities which they were not able to see it before, or at the time of initiation or taking the decision of voluntary liquidation. They are now seeing some new opportunities basis which they are willing to reverse their decision. Out of these three, first two situations, like the fraudulent intention and the assets are not adequate, those two have been taken care of by the regulation 40 of the voluntary liquidation process regulations. Now only third possible scenario is left as to why a company would be willing to reverse the process, and that is that they are now seeing up certain opportunities for the betterment or for the revival of the company. Now, if we look at the basis which I discussed just before that, uh, on the basis of which the company has decided to voluntarily liquidate itself, the time taken by the management to reverse its decision and the time taken by the management to call for the voluntary liquidation of the company, both of these times cannot be so short or so small that company is now taking a reverse decision. If they have given a thought, if they have taken a decision to close a company, it cannot be a hasty decision. It has to be a very time consuming process, very detailed and very uh, the process which has been taken after having long deliberations. So to my mind, the opportunities which are now being seen by the management on the basis of which they want to reverse the process should not be given to the management per se. Rather, it should be given to the other stakeholders like uh, the workmen or the employees of the company who are now willing to take over the company and to reverse the process of voluntary liquidation and give a fresh start to the process. On this background, now let us come back to the questions which has been set out by the IBBI for the professionals to answer. First is, should there be a provision of for withdrawal from the voluntary liquidation, and if such withdrawal is approved by special resolution of the members, partners, or contributors, as the case may be. As I have just said, the process of the provision of withdrawal is partly already taken care of in the voluntary liquidation regulation 40, and the one aspect which is left is to give the option of for the withdrawal to the other stakeholders apart from the management. So yes, the provision of withdrawal should be there with the approval of special resolution. This is my view for the question number 1. And if we talk about second, whether such withdrawal is to be approved by AA, now since till this process, the involvement of adjudicating authority is very minimal, and whenever a company till the stage, you can say till the final report submitted by the liquidator before adjudicating authority for the final dissolution order, all the decisions are being taken care of by the liquidator in consonance with the meeting with the committee of stakeholders. So in that case, to avoid any misutilization of the provision of withdrawal, the involvement of adjudicating authorities approval should be there. Now the third one is, should the withdrawal be permitted both prior or post initiation of process of sale of assets of CP by the liquidator? See, in this case, I have, although this point is not mentioned in the discussion paper circulated by IBBI, if we recall the process of liquidation by adjudicating authority, there a time period of 90 days is generally given for to the liquidator to and to see if there is any possibility of compromise or settlement, and to see that if the company can be liquidated by way of
Amit ji, sorry for
sale through
intervention.
going concern.
Amit ji, sorry for the
Yeah,
intervention. Please try to be brief because we have to take opinion from others. If you can, since you have already elaborated the background, you can
yeah.
quickly chart out your answers on these 4 questions.
I'll quickly wrap up. So in that case, I think the withdrawal process should be permitted only prior to the initiation of sale of asset process, and not after that, because after that, as has in many of the case laws decided by even the apex court, the the liquidation process is a irreversible process. So once the initiation of sale of assets is started, so I think there should not be any permission to withdraw the voluntary asset liquidation process. And the fourth one, if so, what conditions should be imposed to ensure proper checks and balances? As has been mentioned in the discussion paper itself, the special resolution to be passed by shareholders and the majority 2/3 majority resolution by the unpaid uh, creditors has to be there with the approval of adjudicating authority for withdrawal of the voluntary liquidation process. I think that is all from my end.
Okay, thank you, Amit ji, for a very elaborate explanation about the background and why this particular thing should be allowed or should not be allowed. Now, I request Mr. Pranav Damania ji to share his opinion on this subject or on the four questions, and would request all the participants to be brief because we have to take opinion for at least 7 or 8 persons, and we are very particular about the timelines of this. Yes, welcome, Pranav ji.
Thank you. Thank you so much for inviting to the august audience. Since I'm in Mumbai, I really love to be part of this study circle. I hope I'm audible.
You're audible. Your video is slightly not adjusted properly.
Okay.
So, yeah,
Is it good? Yeah.
yeah, it's better now.
Okay. So I would not go too deep on why this amendment has been proposed because it has been elaborated by Sharmaji and Amit ji also. Uh, the basic purpose is that since the voluntary liquidation is more of a regulated process by liquidator himself rather than to approach adjudicating authority time and again, this withdrawal is very thoughtful amendment whereby liquidator is not or this corporate person is not even supposed to approach the AA. That should be my opinion on question number 2. So we'll start with the question number 1. Should there be a provision for withdrawal from voluntary liquidation process if such withdrawal is approved by special resolution of members, partners, as the case may be? Yes, I strongly believe that there should be provision for withdrawal. There cannot be, way that, once you start, you cannot be allowed to withdraw. It should be allowed to withdraw. And if we take the inference from various jurisdictions across the various countries, they have allowed. So, so to my mind, it's very simple. It should be very much in the code itself. It should be allowed. If so, whether such withdrawal is to be approved by AA, I think to my mind, AA's approval should not be required if uh, the withdrawal is proposed before the initiation of sale of assets. Because see, it's the shareholders, it's management who has decided to start the liquidation. At that particular time, you not approach the AA whether I can start the process or not. Now, somebody who has started a process should be allowed to withdraw also without even approaching the AA because this will unnecessarily, be a time-consuming affair, and there is no sense in congesting the AA. So that should, it should be a straightaway approval by the member himself for the withdrawal. And the third, should the withdrawal be permitted both prior to and post initiation of process of sale of assets by CBR? So in that, as I said, if it is prior to sale of assets, it should be allowed even without approaching AA. However, it's very difficult to imagine that what happens at once you started the process of sale of assets, how suddenly there is a possibility of revival and there's a possibility of keeping the company alive and going concern. So that, to my mind, I think that they should require AA's approval. And if so, what conditions should be imposed to ensure proper checks and balance on such withdrawal? So, to my answer for this will be a liquidator or an insolvency professional who has been bestowed with a lot of responsibility. Uh, this even the withdrawal is also whether it is in order or not has to be kind of certified, or it should be approved by the liquidator. So there should be a proper checks and balance on the liquidator part, that this withdrawal is not for any purpose other than it should be an orderly withdrawal. And there should not be any other purpose like defrauding any tax authorities or defrauding any creditors. And the condition is also mentioned that 2/3 of the creditors' consent is required. But to my mind, it should be 90% of the creditors. 10% is reserved, for someone who is very small or who is not even willing to respond. So to my mind, that 67% should be 90%. So I would like to keep it short, and this is my views on
Thank
all four questions.
thank you, Pranavji, for a very short and sweet explanation about what should be done and what should not be done.
Yeah,
Now I request Mrs.
thank you.
Sudha Navandarji to give her opinion. She has been, Pranavji, we handled around 12 cases of voluntary liquidation, and Sudha is also handling a lot of voluntary liquidation cases. So let us hear now what Sudha's opinion about it.
So, hello everybody. This I've been asked for sharing some issues on voluntary liquidation. There are some few points I could chalk out, like which are effects in voluntary liquidation. One is the income tax NOC.
Sudhaji, sorry
Is
to
actually
intervene. Uh, this
yeah.
right now, please provide your opinion on these 4 questions. That will come in the next
Okay.
part. Whether this voluntary
Okay.
liquidation should be allowed or not. If allowed, whether A, approval is required or not, like that. On those 4 questions which are displayed
Okay.
on that.
Okay.
Okay.
Yeah, the first question is obviously yes. It is, of course, there is no reason that why it should not be allowed,
Hmm.
because it's a voluntary, and subsequent, if you find that we need not liquidate the company, one should have an option to continue the company. And about the point number two, I think A, approval is withdrawal is not necessarily required, because it can be done by the approval of the shareholders, and we can simply inform the IBBI, and I think that would suffice. About point number three, it is I think it is better that it is, in fact, it should be done before the sale of assets, because what will be the consequences? It's preferably it should be before sale of assets. And if subsequently, say, if the sale has happened of some assets, then maybe to that extent distribution to shareholders can be done. And if all the shareholders if the shareholders give their consent, then then the maybe withdrawal can be done.
Yeah.
Yeah.
In case the withdrawal is allowed, then what checks and balances should be kept in mind? Like whether the public announcement should be made again, or the approval of creditors should be taken, or any other checks which you have in mind, uh, like the fee of the
Yeah.
liquidator has to be paid or not.
Yeah, the fees of the liquidator, maybe it can be, renegotiated according to the work done, or this thing. And checks means there should be no party should be actually worse off. Like no one should be, like be have something, call everything should be at equilibrium. That I would say.
Okay.
They should not have, yeah, negative impact should not be there on anyone, I would like to say.
Okay. Okay, thank you, Sudhaji. So your opinion is the role of adjudicating authority is not there in case of withdrawals. So now I request Mr. Harish Taneja. Incidentally, we have 3 persons whose cases have been withdrawn in the voluntary liquidation. Apart from myself, Harish also has had such a case. So let us hear Harish's opinion on these 4 questions or anything else he would like to add.
Yeah, thank you, Madhusudanji, for giving me this opportunity to speak on this topic. The first question, as it is mentioned, that should there be a provision for withdrawal of voluntary liquidation process? My answer and my opinion will be yes, of course, when we have been giving an opportunity to withdraw in CIRP also by 90% approval. So obviously there should be yes to this voluntary liquidation withdrawal also. And where the powers have been given to the creditors in case of CIRP, here the powers to be given should be given to the stakeholders. That should be for the creditors as well as with the members. So the special resolution as well as the approval from the creditor should be there if there is anyone. Because when we were talking about for initiation of this voluntary liquidation, at that point of time we were mentioning yes, the approval from creditor should also be taken when we are initiating voluntary liquidation. So the same way when we are withdrawing voluntary liquidation, then approval from both special resolution as well as approval from the creditors. The same process should be followed. This is my opinion in this matter. And second, if so, whether such withdrawal is to be approved by adjudicating authority. When the initiation is not done by the adjudicating authority, so we should not involve adjudicating authority in this matter, because what is the purpose of involving adjudicating authority at this particular stage related to whether the distribution has taken place in the same manner or not? All these things will come when we are going for voluntary liquidation. It is voluntary liquidation withdrawal. So in my opinion, approval from adjudicating authority should not be there. It should be approval from the creditors, or rather we should say the stakeholders. Third question is, should the withdrawal be permitted both prior to or post initiation of process of sale of assets of the CP by the liquidator? Yes, here comes the question. When the assets has already been disposed of or distribution is to be taken place, whether at that point of time withdrawal should be permitted. The purpose of withdrawal will be breached once the assets are being disposed of. Again, then it will be only the company name which will be left out. So the withdrawal should be there before distribution or disposal of assets. So in my view, all these things related to withdrawal should be permitted before disposal of assets. And the last question, what conditions should be imposed to ensure proper checks and balances of such withdrawal? So in this matter, so when we are talking about withdrawal of CIRP, at that point of time, we say 90% approval is required. In the same manner, when it was initiated, what all triggered for initiation of voluntary liquidation? So here the checks and balances related to, one is the special resolution, second is the stakeholders, rather means creditors approval, third, income tax NOC again, and fourth, whether withdrawal is, if it is being done by withdrawal of voluntary liquidation, are we not going against the purpose by which the stakeholders or any other third party or statutory authority may get affected? So even the communication of withdrawal to be given to all the stakeholders, if there is any objection, that should also be taken into account. So one, the approval from all the stakeholders. Second is related to CIRP costs. When we were talking about in CIRP, here also all the means liquidator, all the consultants or the agencies, or if we say advocates or any professional, if it has been appointed. So in that case, all these costs has to be paid, then only withdrawal should be permitted. If it is not, then it should not be permitted. This is my suggestion on these 4 points. Thank you, Madhusudanji.
Thank you, Harish, for keeping it very brief and to the point. Now I'll request Mr. Prabhajit Singh Soniji, whose case also has been withdrawn in voluntary liquidation. So Soniji, please share your views on the 4 questions which have been sought by IBBI, plus anything else you would like to suggest.
Actually,
Soniji,
you just stop my video, so you have to open video first. I cannot start my video
yeah,
now.
you can start. In the meantime, video will be opened.
Okay. First of all, thanks to all, and thanks to Amitji, Harishji, and I'm okay. Starting video is stop. Okay. Now I want to say why we are saying the withdrawal should be get approval from NCLT. I'm saying it should be even the initial period. In the initial period also, there must be something to be done to give some report to NCLT. This stage should be in initiation. Because in one of the case, I got appointed as liquidator, but within 2 months, the liquidation withdrawn without any reason. They just passed a special resolution, and we all see know how this EGM are held. There's no meeting at all. They pass the resolution themselves. So it's hardly any meaning of special resolution. They're all same person. There are only 2 or 3 directors, and they're shareholder also. So special resolution is nothing for them. So why we are preferring there should be special resolution for withdrawal? There must be something strictness. If you have appointed a IP is a legal person, then your voluntary word is gone. Now you are under the control of IP. So there must be some rules to withdraw the voluntary liquidation. So this withdrawal must be done with the approval of A only. And withdrawal should be done only till the date of public notice. If notice has been given and claim has come, then it should not be allowed. Because it's a voluntary liquidation. It's not a compulsory liquidation. You have come to the liquidation of yourself. You know your company is not running well. You want to close the company. You have only cash balance, only balance in the bank only. So it is better. There must be some control. When you appointed IP, there must be some legal person. There must be some check and balances. So from my side, it should be allowed only till Form A has gone. And condition for checks and balances, which I told you, there must be withdrawn only with the approval of some authority. Some legal person should be there, not with the consent of only special resolution. All creditors should say it should be withdrawn.
So, Soniki, just one more question on this. You suggested that the withdrawal should be allowed only till the public notice is given.
Yeah.
Now the requirement of public notice is within 5 days.
Yeah.
So you mean to say that if it is to be withdrawn, it has to be withdrawn within 5 days, not later?
Of course. If you're given the notice, then the claims will start coming. Okay. Then you cannot withdraw. Because it's a voluntary decision. It's not a compulsory decision. In IBC other cases, that's compulsory matter. You have done some fault, and some cases come, and now you cannot draw. You do something, case should not be drawn. But here you come voluntary, so it should not be it should not be done. If you want to go, you have to take approval of A only.
Okay,
and
thank you.
Better it should be from initial.
It should be.
When you file the case for liquidation, it must they must report to A also.
So you are adding a point that unlike the existing provision where A's role is only at the end,
I want it to be from the initiation.
You say that it should be also informed at the initial stage to the adjudicating authority.
Some report must go there.
Okay, thank you.
And also there should be gap of at least 1 year. If you want to come again to liquidation, there must be gap 1 year.
Okay, 1 year gap for another
liquidation. Yeah.
Okay, that's a good suggestion.
Yeah, these are
now I request if any other participant would like to share his or her opinion on these points, they are welcome. Because so far the opinion has been that majority of the participants or the speakers say that there should not be a role of adjudicating authority in case of voluntary liquidation. It is to be withdrawn. But some have the opinion that it's okay, start can be without the adjudicating authority, but withdrawal has to be with the approval of adjudicating authority. So I invite opinion from other members. Either they can raise hands or they can put their audio on and request for. Anybody would like to share? Rajkamal ji?
Yes,
Yeah, I would like to. Yeah, please.
Madhusudan ji.
हाँ जी.
Okay, no problem. Okay.
Rajkamal ji, after you quickly on these 4 points, and then
Okay.
we can take up.
Okay. As far as first point is concerned, I think the decision on the wisdom of the company shareholders and stakeholders should be honored, and that should be allowed. But the only thing is, check and balances should be very strong enough, because if the intention of the shareholders are to revive the company, that should not be objected. That should be allowed. The only thing is, the insolvency professional who has been appointed as a liquidator has an important role in the voluntary liquidation, and his report to AA is important, because he has to certify that there is no avoidance transactions in the company. The purpose of withdrawal anybody is dissenting, then they should be allowed to be paid before allowing the voluntary liquidation to be withdrawn. So there should be provision that the dissenting creditors should be paid off, and then only the continuing creditors can be allowed to with the company. So the checks and balances is a must when the management of the company has decided to go for a voluntary liquidation and they want to withdraw from that, then there must be some equitable reason which needs to be vetted by appropriate adjudicating authority. So there are 4 questions. First question, yes. Second question, yes. Third question should be allowed, and with descending creditors to be paid off. Well, at whatever stage, whether his assets are sold or not, the descending creditors should be paid off, and a report from the insolvency professional that there is no avoidance transactions involved in that. And if the avoidance transactions is there, then that must be first looked into by the adjudicating authority, then only it should be allowed. So that is my submission.
Okay, thank you, Rajkamal ji, for a very brief opinion on these 4 questions. So we invite others. I forgot.
Dharmender ji raising hand.
Yeah. Please go ahead.
Rajkamal ji. Madhusudan ji, thank you. I would like to agree with Rajkamal ji here, and would like to submit my answer. First question, yes. Second, yes. Third, about the stage, I think, it is about the stage at which withdrawal. Both stages can be allowed, but once the sale of asset has been initiated, it should be distributed, and first priority should be given to dissenting or the creditors who have submitted the claim which was not recorded in the books of account. So my humble submission is, in many cases, we have found that voluntary liquidation process has been initiated and the claims are coming, which is not reflected in the books of account, and that's why they are taken by surprise, or statutory authorities are making claims that was earlier not disclosed, as Rajkamal ji said. So this process, in this process, if withdrawal is allowed, they should be given priority or their concerns should be addressed. Then 4th question, checks and balances, if avoidance transaction or any dissent or any concerns have been raised by creditors or any of other stakeholders, that should be addressed. So yes, this is my brief answer. Thank you very much.
Thank you, Dharmender ji. Anyone else would like to share the opinion quickly? We can have we have some 5 minutes more.
Yeah, Sharma ji.
Alok
Sharma
ji.
ji,
Sunil
Alok
ji raising
Kaushik
hand.
here. Yeah. So one point I want to, bring to the highlight is that this will also be good from the ease of doing business as well. Because if a company has done some mistake, then they should be given a chance to correct it. So it's important that we allow withdrawal in case they realize that withdrawal is good. But I think the involvement of AA will be good. Otherwise, it will be a free for all. So people opting for going for liquidation, then withdrawing at their whims and fancies. So it's important to involve the AA for withdrawal process. But the AA would also need some kind of an assurance or some kind of an expertise to tell them why this decision was taken earlier and now why withdrawal. So I think some kind of an audit should be done by a third party, not the resolution professional, but by an authorized third party who also issues a certificate of health kind of a thing to and tell the AA, yes, this withdrawal request is worth considering. And as far as at what stage withdrawal should be allowed, I think at any point of time, if the company wants to, before sale of asset or after sale of asset, because the decision of the company, and if the auditor is giving a certificate, and if the AA is, satisfied, then who else is to decide? So that's my suggestion.
So Alok ji, whom do you suggest could be the third party to verify?
The third party, see, could be, this could be an extreme thought, but I think a forensic auditor could be involved because, situations like CIRP or liquidation, these are special situations. These are not going concern situations.
Okay.
And then further withdrawing is a super specialty situation. Okay, so these need to be examined closely.
Okay.
And then only it should be allowed.
Okay, thank you, Alok ji, for your suggestion. Miss Anuradha.
Sunil Jain ji raising hand.
Anuradha.
Sunil Jain ji raising hand.
Sunil Jain ji. Okay, after that, Anuradha Bishani ji can speak. Jain sab. Sunil Jain sab. Any issue with that?
जैन साहब अपनी ऑडियो ऑन करिए अगर आप सुन रहे हैं तो.
In the meantime, can we request Anuradha ji to
जी.
share opinion?
Go ahead, sir.
Good evening, sir.
Good evening.
Yeah, sir, I think withdrawal in voluntary liquidation should be allowed at any point of time without involvement of a third party. As somebody was suggesting right now that we should get a forensic auditor's consent, I think that will be stretching too far. When the liquidation itself is by the shareholders' approval, then the withdrawal should also be allowed by shareholders' approval. Maybe an intimation to NCLT should do, rather than seeking permission from them.
So what purpose it will serve? Intimation. Because these are statutory authorities and
Yes.
they are not government offices for intimation. So they are to be approached only for approval.
Yes, sir. So in fact, NCLT need not be informed if that is the case. But in case, I think need not be informed.
See, I think I just want to add one point here. As I said, it will be free for all if AA is not involved. Because, there could be some misuse of these provisions of voluntary liquidation process also. So we must avoid those situations. So that's why an auditor or some kind of a report, as Soniji also suggested. So I think that is an important point.
But like I said, voluntary liquidation will start only if the company is solvent.
Right,
Yeah.
but there could be some provision. So some company might think of something. For example, what happens? What is provided for special situation for voluntary liquidation companies? So those situations could be, misused. So we need to avoid such situations.
And you see, it is a statutory process which has been initiated under the code, and a public functionary is involved, that is IBBI, and the IP is registered with IBBI. So it should not be an abrupt process that, okay, all of a sudden that resolution is passed and it is withdrawn. Then we have to think about the interest of the insolvency professional involved who have put in their time and the other stakeholders involved. So there has to be proper checks and balances. We don't say that it should not be allowed. It should be allowed because this is voluntary liquidation, but with proper checks and balances.
Yes, sir. But the same authorities, IBBI and IPA, when we start the process, we inform them, right? We file a preliminary report. So likewise, we can file a withdrawal report as well.
Okay. So we are not arguing. We take the opinion of different.
Yes, sir. Just an opinion only. I'm also not arguing.
I would like to put some points in between.
Yeah, quickly, Vishalji.
Number one, withdrawal. जैसे हम विड्रॉल करते हैं तो इमीडिएटली हमें जो पब्लिक नोटिफिकेशन हम देते हैं सब जगह, यहाँ पे भी एक पब्लिक नोटिफिकेशन हमें देना चाहिए, नंबर वन. नंबर टू, एडजुडिकेटिंग अथॉरिटी के पास जाने की जो हमें जरूरत होनी चाहिए वो होनी चाहिए जब अगर कुछ पार्टली हम डिस्पोजल कर चुके हों. उससे पहले अगर हम पहले प्रोसेस इनिशिएट किया है स्टेक होल्डर्स के इंस्टेंस पर, स्टेक होल्डर के इंस्टेंस पर ही हम प्रोसेस अगर बंद करते हैं तो इट शुड नॉट बी सब्जेक्ट टू एनी एडजुडिकेटिंग अथॉरिटी अप्रूवल. हाँ, अगर कुछ एसेट्स हमने बीच में चले गए हैं या कोई डिसेंटिंग शेयर होल्डर है या कोई स्टेक होल्डर कोई भी है डिसेंटिंग, वो एडजुडिकेटिंग अथॉरिटी के पास जा सकता है. वो ही इज फ्री टू डू दैट आफ्टर दैट पब्लिकेशन.
ओके.
और सर एक थोड़ा सा मेरा इसमें सबमिशन ये है कि व्हेन वी फाइल एन एप्लीकेशन टू एडजुडिकेटिंग अथॉरिटी.
हरीश जी, आपकी आवाज कम आ रही है थोड़ा.
हाँ जी सर, अब आ रही है?
हाँ, अब आ रही है.
सर जब हम अगर विड्रॉल इफ वी आर अप्लाइंग टू एडजुडिकेटिंग अथॉरिटी, दैट मे टेक अनदर 1 year टू गेट द विड्रॉल इंप्लीमेंटेड बिकॉज़
Agreed.
No, that's correct. But in the Companies Act also,
process, because they are also overburdened as on date, and there's so many pendencies which are there. And again, for individual insolvency and these personal guarantees which are also coming up, will again they will be burdened more. So if we will file one more application of withdrawal and we will burden them more, that may lead to again 1.5 year for withdrawal to be implemented. And again, insolvency professionals in the meanwhile will stuck up with all these processes, will not be able to do any other thing. So even for insolvency professionals, till the time withdrawal is not approved by adjudicating authority, will become a cumbersome process for him also. Every time he needs to mention wherever he is giving consent, because till that particular time it is not approved by adjudicating authority, his process is on. So that assignment will also be counted for that purpose, because when we are going for too many assignments, which IBBI is thinking for. This is my submission, sir.
Thank you, Harish, for pointing out this thing. Anyone else? Sunil ji, could you unmute yourself and would like to share your opinion? Mr. Sunil Jain. Or Vinod, you would like to share some?
Nothing to add, but I am very much concur with the view of the Harish. This NCLT process will entail heavy cost, either in terms of time or money. It will take not more than 6 months, not less than 6 months to have an approval. By that time, whatever the business opportunity the stakeholder management of the company is considering, that business opportunity may get lost. Like in the Corona time, some pharma company is there who has proposed for the voluntary liquidation. Now having some business opportunity till the time waiting for the approval of the NCLT, this Corona is over. Whatever the business opportunities they were conceiving, that may also get lost.
Okay,
so again they have to come for the voluntary liquidation again. So having a complex process like taking approval from the adjudicating authority may not work. Simply intimation to the ROC, central government, income tax, or the IBBI, the process should be closed with the condition that the whatever the fees of the IP is proposed has been paid off with an undertaking.
Yeah, thank you, Vinod. Mr. Manoj Kumar, advocate, wants to say. He has raised hand, so please unmute him. Mr. Manoj Kumar.
सर मेरा बेसिक क्वेश्चन है कि वॉलंटरी लिक्विडेशन स्टार्ट होने के बाद कंपनी का कंट्रोल ओवरऑल किसके पास रहता है? अगर वो लिक्विडेटर के पास रहता है तो स्टेक होल्डर्स का राइट सिर्फ डिस्ट्रीब्यूशन को लेके है। तो अथॉरिटी को अप्रोच करने के लिए कि वॉलंटरी लिक्विडेशन विड्रॉ होना चाहिए या नहीं होना चाहिए, ये जब तक अथॉरिटी अप्रूव नहीं करेगी उस चीज को, क्योंकि वॉलंटरी लिक्विडेशन एक बार स्टार्ट हो गया तो स्टेक होल्डर्स का राइट कंपनी की डिस्ट्रीब्यूशन को लेके ही रह गया उनका, और किसी चीज को लेके नहीं रह गया कि विड्रॉल होना चाहिए नहीं होना चाहिए। अंटिल अथॉरिटी उसको अप्रूव नहीं करेगी, वॉलंटरी लिक्विडेशन अलाउड विड्रॉ नहीं हो सकता।
So your opinion is that without approval of adjudicating authority, voluntary liquidation should not be withdrawn.
Yeah, because there is a basic question कि अगर वॉलंटरी लिक्विडेशन एक बार स्टार्ट हो गया तो कौन कंट्रोल में है कंपनी के?
Here, as you asked, the situation here is slightly different than the compulsory liquidation. Here, the powers of the board of directors are not suspended, but the only thing is that they can't carry on a business after this voluntary liquidation has been started. But they can call AGM. They still enjoy the powers of directors.
But sir, section 59(6) अगर हम देखते हैं तो उसमें लिखा है कि प्रोविजंस ऑफ 35 to 53 वुड बी एप्लीकेबल, एंड 35 में जब हम जाते हैं तो 35(2) में वो कहता है कि लिक्विडेटर शैल हैव पावर टू कंसल्ट विद द स्टेक होल्डर्स।
No, that is true, and that's the reason why 33 and 34 are not made applicable to voluntary liquidation. Because 33, 34 talks about suspension of the powers of the board of director, which is not happening in case of voluntary liquidation. But your view is taken that it should not be allowed without the approval of adjudicating authority. Any opinion regarding at what stage it should be allowed or what stage?
I think it should be at any stage.
Any stage.
Even if you have sold the property, but if your realization is sufficient to distribute for the distribution of the stakeholders.
IPs who have done number of cases on voluntary liquidation.
One point, Sharma ji, I want to make here that the one point was raised that the NCLTs are too some other authority may be constituted who could look into such issues.
Okay. Thank you.
Sir, my submission is when we start the voluntary liquidation process, we are not consulting NCLT. So hence for withdrawal also, we need not go to NCLT. What we are doing at the beginning of it, we should do the same thing even while withdrawing. Only for the concluding part of it, we may go to the adjudicating authority. This is my submission.
Okay. If the sale has started, then all the creditors should approve. So apart from that, since we are all professionals and we are working for these assignments for our professional income also, no one has taken care of this professional fee. Suppose the voluntary liquidation is withdrawn, then how the fee of IP is to be protected? When Section 12A was inserted for CIP withdrawal, there is a provision that there should be a bank guarantee related to the cost of CRP and the expenses and fee of the RP. So there should be similar provision that yes, okay, this is voluntary liquidation. It can be withdrawn with EGM and some other checks, whatever is instituted. But there should be a security or surety for payment of the fee of the RP concerned. It should not be that he is left in lurch.
I wish to add one point that withdrawal intimation for the withdrawal or liquidation proceedings can only be under the signature of the RP be intimated to the IBBI or other statutory authorities. That has to be under the signature of the IP only. By that, you can ensure the sanctity of the process either for the fees or all other compliances.
Okay, thank you, Vinod. So,
And the fee part should not be an issue because the company is solvent. So maybe since the company is solvent and now withdrawal, so that means you still want to continue the business. So an undertaking from the management or the shareholders resolution itself that the balance amount or whatever is the balance to be paid.
yeah.
So that can be considered.
Yeah, the company should be solvent and it should pay that fee.
Yes, sir. Sir, voluntary liquidation, the very base of it is that it has to be solvent.
True.
But intention of fees, whether is there or not there, that is the questionable. Na? If it is made like that, the intimation has to be under the signature of the IP, then it only can be taken on record. Then only that way the management shall be enforced to release the payment of the IP.
Absolutely. See, as every process is starting, like the preliminary report also, which we submit to IBBI, that goes under the signature of the liquidator. So the same way, even the withdrawal has to be in the same way.
Yes, if the voluntary liquidator signs and with an undertaking that all the necessary compliances as proposed by the Act, Code, or the regulations have been complied with, and after making such an undertaking, if the voluntary liquidator signs, then it should be taken on record, and the voluntary liquidation should be allowed to be withdrawn.
All this can be part of the resolution.
So, can we now close this discussion?
Sure.
I hand over it again to Ms. Anchal for the other process where we will be sharing the experience of the IPs who have handled number of voluntary liquidation cases. And I'll only request the speakers to be brief, and because we want to keep at least 20 minutes at the end for question answers from the participants, because we have such people who have handled more than 10 cases of voluntary liquidation. So over to you, Anchal, again.
Thank you, sir, for giving me back. First, I invite Mr. Pranav Dhamania ji. He is a qualified IP, CA, and CS with over 20 years of experience as a CA. He has completed voluntary liquidation of 4 companies under Section 59 of IBC and currently handling 8 voluntary liquidations. So, Mr. Pranav Dhamania ji, kindly share your experience in voluntary liquidation matters. Mr. Pranav Dhamania ji.
Yeah. Thank you. So my experience is with respect to the overall general handling of the voluntary liquidation rather than relating to the withdrawal, because I have not handled any case where the withdrawal has to happen. Although there has been a lot of discussion regarding few companies who wanted to go for the liquidation, they were not sure because of there was no withdrawal mechanism. But I think with this withdrawal mechanism in place, there would be much clarity, and that would bring a lot of ease of doing, as one of the participants has suggested in this entire process. My experience overall has been good, except there are delays which are beyond liquidator's control. There are delays happening on the income tax and NOC part, and there are delays happening on the adjudicating authority part also. Uh, the first few cases has happened in 1 or 2 hearings maximum, but recent experience has been like 4-5 hearings. The orders are not getting uploaded, the hearings are not coming up. So with this kind of already delays happening, I strongly of the view that the withdrawal process, if initiated before the sale of any asset, it should be automated. in the sense there should not be involvement of
Sorry to intervene, Pranavji.
Yeah.
This is your experience on the voluntary liquidation cases which you are doing or completed. We are not talking now about the withdrawal. That withdrawal
Correct.
discussion is over.
I'm just trying to connect the dots. So the experience has been
just a minute, Vinodji, you please mute your mic.
There has been delays beyond the control of the liquidator, and that should be sufficiently addressed probably at NCLT, and there should be a dedicated hearing for those kind of cases. That should be my take based on whatever experience I have. So that's what I have to say about the experience and the voluntary liquidation so far.
Any special situations which you have come across which you didn't expect when you started the voluntary liquidation process, or what precautions the insolvency professionals should take before taking up the assignments?
Yeah. So my experience in this is very unique. I have Fortune 500 group companies who says and who certifies by their attorney general, saying that the company has absolutely no pending litigation, or the tax records are all clear. They end up having so many open issues, like tax assessments are pending, or some compounding is pending, or something somewhere is pending to be not complied, and we end up spending a lot of time in clearing all those messes, for which we don't get paid also, and the process which should ideally get completed within 6 to 9 months maximum, it stretches beyond 1 year, 2 years, sometimes more than 2 years also. That's my experience. So as a liquidator, before before you take up the appointment, it is very, very essential that all the records, at least the tax records on the employee side record, should be checked, and then only you take up the assignment, or with the knowledge that these are the pending assignment, then you can build up your time commitment and the fees. So this is my advice, because a lot of MNC companies which I come across, they simply fail to recognize this, and we end up clearing their messes. So this is my suggestion based on the cases I have handled. So due diligence, basically.
Thank you, Pranavji, for sharing your experience. Now I invite Mrs. Sudha Navarji. She is a qualified IP and a CA with 25 years in practice. She has handled more than 10 voluntary liquidation cases. She is an independent director in 3 companies. Mrs. Sudha, ma'am ji.
Yeah.
Ma'am, please share your experience.
Yes. See, it is like there are, as Pranav said, there are many issues which keeps coming up. It seems a small task, but there are so many issues which keeps coming up, and we have to handle up and be innovative in how to solve those issues. So one is, of course, that what you said, the NOC income tax is a lot of time consuming, and we keep, the assignment comes to up, and we keep waiting for the income tax no dues. We have to do lot of follow-up, and then the annual procedures also we have to comply, because and there's no work also, but then you have the work is assigned to you, so you have to nurture it. You have to do the audit, get the account audited, and hold the shareholders meeting, maintain minutes, and the continuous reporting has to be done to IBBI, and all the this IC triple I. So all that compliance comes to us, and what is that? The fees is of course lump sum. So even if you the work is on the but fees is like whatever is pre-decided, and the delay is subsequent, so we are not able to assess. I mean that is one thing. And what precautions one Madhusudanji said, yeah, one what is we can do the search, ROC search we can do if anything like that. Is we have to study the balance sheet fully, the notes to account, everything, and we have to really understand the company. So if any hidden matters are there, we are abreast upfront. Then one of the this thing, one challenge is what you have asked, unforeseen happened, where there is a company with foreign shareholders. So when we started final distribution, we asked the bank for the documents required for the final remittance. So one of the requirement was ki you have to give a certificate from auditors that all the liabilities of India has been paid off. So now the earlier auditor were the Big Four, and now we had appointed for like this period for this case the only 1 year has passed, so we had appointed another auditor, a CA firm. Now when we asked the bank, they wanted the statutory auditors. So then we went to the Big Four and we took their that, and we were also comfortable being an MNC company. We thought we'll get a certificate from the Big Four, so we know safety and like for us we'll be better safe. The Big Four has been given this, and then we can done the distribution. So that took 1 year. So many requirements, that engagement letter, everywhere they are, they were so strict.
Sudhaji, we are missing your voice.
With that, and our company also agreed to their terms of engagement for this certificate. So that, and 1 year delay was only for the certificate. That is and I think yeah, this was one experience I wanted to share. Yeah. And in that income tax NOC, many people write in the engagement letter itself that it will be obtained by the company. So that can also be done, so that our efforts are saved.
Thank you, ma'am. Now I invite Mr. Rajkamal ji. He is a qualified IP, CMA, and a CS, and a registered valuer in securities and financial markets. He has a wide experience in handling these matters. Please share your views, sir. Your voice is not coming, sir. Oh.
Sorry.
Yes.
I would like to start with the background why the voluntary liquidation is required. And voluntary liquidation is required when there is no business with the company is solvent. The basic two aspects are there. And the law has given the liberty to the company to withdraw. Now, there can be a background of the company that the company is small, and the company can be had a background that it has a good business and good operations and have got a multiple licensing and all those things. When the assignment is offered to an insolvency professional to go for voluntary liquidation, it's important that the voluntary liquidator must assess before accepting the assignment that whether the endeavor and the timeline which he is required to devote is quite well remunerated. So due diligence is the important aspect before accepting the assignment. That is the thing. That is my focus point in my discussion. Now, in the voluntary liquidation, there are driving forces is the corporate person, board of directors, and shareholders. Creditors are there. Creditors, if they they would definitely like to have their money. They have got the limited role to play, because getting the special resolution from them, getting that's just a formality that they so that they get the money back. Now, liquidator's role in the voluntary liquidator is quite different as the liquidation after the CIRP. After the CIRP, the company is already in case of CIRP, the company is already in a bad shape, and the law has given that whatever is available can be distributed to the under Section 53 according to the waterfall mechanism of Section 53. Now, in case of voluntary liquidation, the reporting is restricted to the stakeholders. Now, the stakeholders and when in case of normal liquidation, it is to the adjudicating authority. Adjudicating authority has basically giving a shelter to the liquidator in that case, whereas in the voluntary liquidation, the entire thing depends on the liquidator himself. Now, what is the expectation from the liquidator? That is that the CP has closed all the matters of the corporate person has been closed. That is the important thing, which is the prerequisite for the start with the voluntary liquidation. And what is the document they are offered? They are normally offered with the balance sheet. Now, the balance sheet is not the complete statement of the state of affairs of the company. There are many hidden things which is not disclosed or not available in the balance sheet. Now there may be certain litigations which has not been reported in the balance sheet at all. Now, there can be certain licenses which has got some added conditions that must be closed, and there are some there may be some you can say there's some compliances pending, and all those things are there. Now, similarly, there may be some transactions which have got impact on the health of the company, because there may be some avoidance transactions which are there, which may not happen within the last 2 years, but still have some certain things is there. So the due diligence and all these impact the duration of the liquidation, as the previous speakers have spoken, that they have experienced that the voluntary liquidation, they have estimated that it should be within 6 months to 9 months. Now it is taking 1 year, 2 year, 3 year. Now, taking the time cost on the basis of fixed fee is very challenging as far as the voluntary liquidation is concerned. Wherever the company was really active, and I'm differentiating the two type of companies. One is very small, only bank balances are there, that can be closed within 6 to 9 months, that is always there. But as far as the companies which have got a background, that needs to be examined very properly. Now, wherever the companies are having foreign shareholding or subsidiary shareholding, and they have got the transactions which are subject to transfer pricing also. So the income tax matters might have been pending as far as the transfer pricing matters are concerned. So, and all these things has got impact on the getting the NOC from the income tax department. And normally in such type of companies, getting the NOC is really challenged, because at times what happens, they start the special proceedings once the liquidator gives the letter that the company is going for a voluntary liquidation. In that case, income tax authorities, before giving the NOC, they start the 263 proceedings, and they see all the aspects before giving the NOC. So my submission is, before taking any assignment, the proper due diligence must be made. That is litigation for or against the company, whether the arbitration proceedings are pending or not, so whether all the licenses have been surrendered, duly complied, whether GST registration has been surrendered, whether income tax assessments are complete and no litigations pending, no non-compliances confirmation from the under FEMA from the Reserve Bank of India, and whether any PUFE transactions are there or not, and records of the company are also required to be kept for 8 years. So liquidator has to inbuilt proper system so that the company's records, as per the Companies Act, are also to be kept for another 8 years properly. So these are the things. Apart from that, the real conflict comes in the running of the voluntary liquidation is regarding when he wants to comply with all the things that he need help of the help of the independent professionals, and they want to appoint the professionals, and the stakeholders are objecting about such appointments, their fees, and uh, auditor is required at every stages. There are many things which is required to be certified by auditor. So auditor appointment is one of them. Income tax matters are there, and if any after even start of the liquidation process, if any financial is completing, the income tax return is to be filed. If any payment is made, TDS return is to be handled. NOC is always there. If the non-resident shareholders are there, then certificate under section 195 is required. And wherever there is an accumulated profit, then again dividend distribution tax are there. So these are the things where he needs to appoint the special professionals also. For that also, the fees is required to be expenses to be done, where the stakeholders give normally objection that you are making so many expenses. So these are the things. So these are the things. These due diligences must be done before accepting the assignment, so that the liquidator is well paid off, and he can run the process very smoothly. So that these are my submissions on this matter. Please. I hope I'm in within time.
Yes, sir.
Yeah.
Thank you. Now I invite Mr. Amit Sharma. He is a qualified IP advocate, CMA and a CS with over 15 years of experience having handled liquidation matters. Mr. Amit Sharma, you also share your experience.
Sorry to intervene, Anchal. Now there is a panel of question answer. So Amit Sharma ji, Sudha ji, and Pranav ji will answer the questions if any from the participants. So
one question is from the chat
I'll
box.
request all these three to put their video on, and they are available. Sudha ji, Pranav ji, and Amit ji.
So this is one question from Anuradha Bisnai. Till which date the ROC and IT compliances has to be made for company in voluntary liquidation?
Hello?
NOC, what is talking here?
Daji, would you like to answer for the same?
NOC of income tax?
Yeah.
ROC and IT compliances.
Yeah, actually, this income tax is under section 178. You can just refer that, section 178 of the Income Tax Act. When we have to inform in 1 month, and then that whether any tax liabilities are there or pending, then the income tax authorities are bound to reply in 3 months. But they do not reply, we have to do a lot of follow-up.
So just add up on this question. The 3 months time is given for Income Tax Department to provide NOC as per the amendment made through IBC. Whether the liquidator can proceed with distribution after 3 months, or he has to wait indefinitely for the NOC. Can the liquidator make partial distribution or final distribution after 3 months, or say waiting after 4 months, or he has to compulsorily wait for NOC?
We are waiting for the NOC compulsory, because in fact the NCLT also asks for the NOC of income tax in the hearing every time for every case. So as it is, the matter will not close. So we always wait for the NOC and then only distribute.
So can you distribute partially without IT NOC? If you have money available, and your there is no demand raised, say for 6 months, and your assessments for previous years are over, then still you can't do any distribution?
I mean, I have not experience in this matter. I think it is allowed as per this income tax. It is allowed, but it's a call the IP has to take.
Okay. Pranav, what is your opinion?
So, yeah, my answer is if as a liquidator you would have checked all the records and there has been no assessment pending or nothing is pending. If the income, you wait for 3 months, of course, but if the income tax officer is not responding and there is a pressure from shareholders, then at least partial distribution you can do, provided you have sufficient balance in case some demand comes up. But it's all depend on the case to case basis, where there are companies where there is absolutely no it's all records are very clear, assessment has been done and there's no demand, no appeal, nothing is there, then probably you can take some lenient view and distribute partial to the shareholders.
Okay, thank you. Amitji, your any opinion or different opinion on this?
Sharmaji, I was fortunate enough to get the NOC from Income Tax Department and in the very first instance itself within a month's time. So I didn't experience any such hassle.
Okay, but your opinion, in case this is not received, then can the liquidator go ahead with partial distribution? If the
Section 178 is very much clear that you have to intimate only, and department has to respond within 3 months' time. And if in case you are not receiving any revert from them within stipulated time frame, then you will have to take a call. Okay. And I experienced in one of the hearing before Honorable NCLT that in any case, I was attending the hearing and I got to listen the remarks of NCLT in another case, wherein NCLT had said that in any case, government's dues are on a very later stage of priority under Section 53. So you need not to wait until that stage is arrived. So that was, in any case, either they have to file a claim for their dues before the liquidator, and if they are not doing so, or even if they have done that, you will distribute as per the Section 53 distribution schedule. So until you reach that stage, you need not to worry about waiting for the income tax dues.
Okay, thank you. Vishalji, next question. Yeah, Sudhaji, you
Sir,
want
but that thing, Section 53 arrives only for the liquidation process, not for voluntary liquidation. So,
Section 53 is equally applicable to voluntary liquidation.
Sir, but then it's a solvent company and we are given affidavits that whatever dues are there, we will pay up. So even if it falls under the F category or Y, whatever category,
that is
you
true.
still have to pay.
That is true.
And sir, my question earlier was, till which date do we need to do the compliances as for MCA and income tax? Until we file, I mean, the resolution is passed, or until we file the application with NCLT for closure under Section 59?
My answer would be till we make the application with the AA. Till that time, you need to do all the compliances, and probably there are instances where we are still doing surrendering of pen and pen after the order also. So your job still continues in that sense.
Yeah, see, surrendering is one part. What I'm asking is, like, suppose, I'm supposed to conduct the AGM. So should I be doing it even after?
AGM we don't conduct. We don't conduct AGM.
Okay.
And what about the income tax return filing? If, for example, the liquidation commencement date is in the middle of the year, so do you need to file that return up to the commencement date or not?
No. The income tax follows the assessment year March ending. So whether it is starting in between, you have to file return only at the end of March. That's very clear.
No, return filing only at the end of the March, but for the period before insolvency commencement date or for the full year?
Full year, full year, full year.
इसमें थोड़ा सा मेरा मैं अपना इनपुट देना चाहूंगा. इसमें what I feel until company is dissolved by the order of adjudicating authority, all compliances which are going on must unless until registration got cancelled, it should be complied. Rather, it should whether it will be of ROC or income tax or labor law, if applicable any. If registration are existing, registration not get cancelled, not get over, it should be complied till dissolution order filed with ROC. It's my take.
So ideally what we do normally in liquidation cases, we surrender all the licenses except the last PAN and 10. 10 also we sometimes surrender. Only the PAN sometimes.
Sir, I'm sorry to interrupt you.
Yeah.
10 is required because when you will make distribution of the proceeds, then you have to comply this tax deduction rules also.
Correct, correct. So that is, I'm saying after the dissolution order, the only process remains is the surrender of PAN. That's what we do.
Okay.
Another question is whether INC 28 is required to be filed for voluntary liquidation.
Yes. Yes, we are filing it.
It is required.
Yeah.
Is NOC from creditors?
So my question for INC 28 is that who will file the INC, when it has to be filed? Once the resolution is passed for voluntary liquidation, then the liquidator will file, or once it is approved by the NCLT, then it has to be filed. So there are two different scenarios.
Once
yes, please.
Once the NCLT passes the resolution order, that will get filed by the liquidator with the MCA, and that is what the intimation to the ROC about the dissolution order. On top of it, you can also file the physical letters along with the orders also.
So that means once the resolution is passed by the shareholders for voluntary liquidation, then we don't have to file INC 28. It is only when the NCLT approves the dissolution, then the INC 28 has to be filed.
Right.
Friend, we require to file MGT 14 at the time of SR is filed by the SR is passed by the members.
Correct.
Thereafter, when adjudicating authority pass the order, then INC 28 is required to be filed.
Perfect. Perfect. Right. I got the point, sir. And on the same pattern, sir, when we are talking about the compliances part, let's say the order comes for dissolution, let's say on 20th December, for example. So for the period 1st April to 20th December, do we need to file the income tax return also? That there's a part year which has been getting completed because the company is getting dissolved?
It will be required. It will be required. It's my view. Yeah, it is required.
It is required. So even for part year, we have to file the final income tax return. Then only we can surrender the PAN number.
For the purpose, section 178 may be referred and rules related therewith.
Okay, fine.
Till the time your balance is zero, you have to file the income tax return.
Fine.
So that leads to another question. If you see, the provision is that you get NOC from the income tax department within 3 months of your intimation, and then you can start distribution. And thereafter, the year end comes and you are filing a return. And let us assume theoretically that then the income tax department demands something out of that, and you don't have any money. How will you deal with it? Because you are dealing with the part year, which is before the insolvency commencement date, and then you have done all the process, you have distributed it after taking NOC, and then when you are filing the return for the current financial year, if there is a demand, how do you tackle that? And is there any situation like that?
Sir, there is one situation is correct, बिल्कुल clear है कि NOC जो department देगा, वो देगा as on date. कि आपके कोई पिछला कोई ड्यू, कोई असेसमेंट, कोई पेंडिंग डिमांड तो नहीं है। और जो जिसके हम बात कर रहे हैं नेक्स्ट रिटर्न की, उसके लिए असेसमेंट, सेल्फ असेसमेंट इज रिक्वायर्ड टू बी मेड बाय द लिक्विडेटर हिमसेल्फ and file the return on if he anticipate any tax liability may arise during the course, then he has to make a provision for that.
May I
keep some money apart for that.
May I? Sir, इसमें first we need to surrender PAN also. The PAN surrenderation will be only accepted after all the liabilities are cleared. First level. Second level, when we are filing the dissolution application with the adjudicating authority, then the service has to be done on the ROC and income tax as well. Income tax report is required there. Income tax can also raise demand there itself. So there are, even after the distribution, there are two levels still left. First is the surrender of a PAN certificate, and second is service at the time of the filing the dissolution application. If any liability arises by virtue of the insolvency certificate granted by the stakeholders, shareholders, then this amount needs to be contributed by the stakeholders.
Correct. Okay. Can we move to next question? Is NOC from creditor mandatory while replacing liquidator? Special decision of shareholder are already passed for replacing liquidator. Anyone?
Replacement of liquidator in voluntary liquidation, I have never come across.
The provision has been added recently.
Yeah.
SR is passed. My question is, SR is passed. NOC from creditors mandatory. This is from Arpita Bajaj. This question is from. Anyone would like to comment? Is NOC from creditor is mandatory while replacing the liquidator? When shareholder has already been passed the resolution?
I don't think there is any specific provision for that in the regulation.
Sir, my view on this is, there when voluntary liquidation has already been initiated, now all the members, whether it is an equity holder or it is a creditor, become a stakeholder, and anything is to be done. If replacement is being done by of the voluntary liquidator, it will be done by the stakeholders meeting, joint meeting, and you cannot say equity holders can pass the special resolution and creditors are left apart. It cannot be done. All stakeholder has to pass the resolution. If it my view. Now others
Vishal, there is no provision of stakeholder consultation committee in the voluntary liquidation. It is only there in the compulsory liquidation. So the regulations doesn't require it. And I think this amendment regarding replacement of liquidator has been very recent one. And the only requirement seems to be resolution from the company, not from the creditor. Pranav and Sudhaji may correct.
Yeah, correct. And probably, I think the thought process for not obtaining creditors would be, it's up to, it's my mind only, that creditor consent is required for liquidation process. It is not required for appointing any professional. The appointment of professional still lies with the shareholders. So if the shareholder wants to replace, they can do it without going back to the creditors. Creditors are only concerned that for the liquidation process, their consent is there, but not for the appointment or not for the replacement of the IP or the liquidator.
Okay, Vishal,
Sudhaji, your view?
I endorse the view.
Yeah,
So
Vishal, you can take next question, because we have a lot of questions and we'll have to complete it in time.
Whether NOC is required from
Vishal, yeah. Vishal, what you had said, Vishalji, but in compliance, what you said, no? Actually, in the ROC website, we have to ensure that the status shows is involuntary liquidation. And then once the status comes as in liquidation, then you are not able to file the regular filing, and you are not allowed only to file. So that you don't have to comply on that part. You
Madam,
cannot do it.
all those filings are required to be done in form INC 2, if I'm not wrong. And all the if you have to file 20B, 23AC, it is required to be
No,
filled hand and get
No,
it
no, nothing is
and
not.
get
it
it
is
filed.
not. It is not required to be filed, and you
It is
cannot
not
file
required.
only.
Yeah, yeah. Not
It is
required.
not required.
It is not required.
Not required.
Not
But
required
we
and
have to
system doesn't
ensure
allow it.
by our.
I just got a dissolution order from Honorable NCLT, and I have not been able to file it with file the INC 28 or GNL2 because it is saying it is not available for e-filing.
Okay. So then how do you go ahead?
I had to email it to ROC, and I am requesting them either to take it on record or rectify the error at the allow me the e-filing or take it on record through email. So that is what I am doing.
Manual filing we can go.
Yes,
Is
we
it
have mailed
allowed?
it to ROC.
Okay, whether NOC is required from GST if
Yeah.
it is registered with GST.
Yes.
Yes.
GST surrender is required. Once you distribute all the assets which is subject to GST, that surrender is required before going ahead with the final distribution. I think so.
सतीश कुमार जी पूछते हैं, how many years to be checked for preferential, defrauding and extortionate and fraudulent transactions by the liquidator? Also, for how many years record to be keep by the liquidator? Who will file the e-forms for 14 and GNL2, whether by director or liquidator? There are three questions basically. First is how many years these avoidance transactions could be examined by the liquidator.
The avoidance transactions are very much same as the liquidation process, 2 years and 1 year.
Any other view? If the liquidator is finding anything which has a essence in the last 2 years or 1 year, depending upon the related party or non-related party, and if anything is there which shows that there is some avoidance transaction. Suppose for illustration, I am giving you one illustration. Suppose the one asset was sold before 2 years. Now you have received the assessment order from the income tax department in your period, and where you find that the income tax department has made a substantial demand on the value of the assets as showing as undervalued, and that demand is not contested by the management and it is paid. So that means it clearly shows that some fraudulent transaction is there. In that case, that transaction needs to be examined, even that transaction is before the period of 2 years. So that avoidance transactions that needs to be examined. So I'm just giving you an illustration where we need to have a link for the prior period. If suppose
meaning
you have
fraudulent transaction can be seen even prior to 2 years.
Yeah, prior to 2 years, and within 2 years, if you do not have any fraudulent transactions, then you only have to see the undervalued transactions or preferential transactions. In regarding the preferential transaction, I'm of the view that is not required in case of voluntary liquidation, as because the company is solvent, and when the company is in the running position, they have made any payment. It is not that they have given any preference. Their intention is to pay to all the creditors. So the preferential transaction has got money. I don't think it has got any relevance as far as the voluntary liquidation is concerned, because the company is solvent. If it is not solvent, then everything is on the question mark. That's a separate thing. If it is solvent, then I don't think it is at all required to be examined from that aspect.
Okay, sir.
I would just like to add, Vishal, I would just like to add that as far as the section 49 undervalued transactions and section 66 fraudulent transactions are concerned, there is no time limit.
Yeah.
That is only for 43 and 45 and 50.
Right.
So fraudulent transactions, there is no timelines. So
yeah. And second part of the question is, for how many years record to be kept by the liquidator, preserved? preservation of record.
I would like to answer this question. If anybody wants to add on that, they can do. There are two parts of it. One is under the regulation, that is of the records of the liquidator. That's a separate thing. And one is under the Companies Act, which is the records of the company. So as far as the records of the company is concerned, the Companies Act will govern. And as far as the records of the liquidator is concerned, we need to follow the regulations. So for companies also, we need to keep the records for at least for 8 years, and that arrangement need to be made. Now the agencies, many agencies are available which are providing the services. They are keeping the records for the on payment of certain fee, and even any SL also is providing in that electronic form that is to be kept. And that compliance, I think, is a must. That must be done.
So I'll request Sudhaji and Pranavji to answer. If is it the responsibility of liquidator to also maintain the records of the company prior to insolvency commencement date, or it is only related to the liquidation process which is being carried on by the liquidator?
Technically, liquidator is only liable to keep records due for his process whenever he is there, his tenure. That's a very simple and very straightforward answer. However, now there is a second angle. If income tax or if any government authority wants to examine the records, whom do they contact even after the liquidation or during the liquidation? So they first contact the liquidator. So in that sense, he is indirectly involved, and his responsibility is there in terms of it is ensuring that the records are available to the authorities.
Sudhaji, would you like to add something to that, or you agree with what Pranav says?
We have to, like, when the liquidation commences, we have to obtain updated accounts from the client, and then we have to manage the accounts. And the support of management is always there for any queries on whatever is, comes from income tax. They are, it is can done with jointly with the. I mean, we can. This all respond to the income tax.
Amitji,
third part of
with help from the client.
sir, we should move to the third part of the question.
Oh, okay.
Who will file e-form MGT 14 and GNL 2 in case when special decision is passed and GNL 2 is required to be filed at the time of voluntary liquidation initiation? Then who will file these documents? Liquidator or the management?
The director has to file it, but what we do, a letter, we authorize that since although we have been appointed, and then we are like, we give the authority to you to sign on behalf of the company, because in the first in 1 week only we have to do, so we always give a letter to them authorizing them to sign. So under our authorization, there is affixed.
Any other addition view on that?
Because Vishal, we have 3 more questions and we have to complete in time.
Yes.
So
next question is, NOC from PF authorities have intimated inspection. What to do? You have nothing to do. You have to get inspection done. It's simple, I think. Any addition?
Actually, after intimation to PF department, that please provide us the NOC to proceed further. Instead of providing NOC, they have started inspection and have raised the demand. After demand, they have now raised penalty and interest on penal interest also. They have raised a huge demand. So they are not allowing this process to be completed, and they have now started protracted litigations. So there's a problem is cropping up now in voluntary liquidation when we go to GST authorities or PF authorities. So we are not able to complete this process until and unless we get the NOCs from the PF authorities.
Brother, you have NOC in your hand. you left no other option but to go to adjudicating authority.
What is the experience of Sudhaji and Pranavji in handling so many voluntary liquidation cases? Did you have such type of problems from profitability?
We don't specifically ask for NOC from the PF department. I think the public announcement is there for everyone. So we don't normally ask, we don't in fact don't ask any specific NOC from PF authority.
Okay.
We also don't ask, only we have intimated them. Like if there is some like employee were there or something, we just have intimated that we have initiated voluntary liquidation. Let us know. We have written a letter for our safeguarding ourselves.
Amitji, how's your experience?
Wherever applicable in that matter.
Amitji?
Sir, as a liquidator, my responsibility is to invite claim from all the departments, and public announcement is sufficient. However, in order to safeguard myself, I write individually to each department, and I think that is sufficient. If they want to file a claim with me, they should do it. Otherwise, I'll have to proceed ahead with as per the regulations and the sections.
The problem is in response to my intimation, they have started doing the inspection.
Yeah, that is.
We have to move to another question now. In addition to filing of e-forms 14 and GNL2, liquidator also write a letter or email to ROC informing about the voluntary liquidation. Sir, in my view, another GNL2 is required can be filed by the liquidator intimating his appointment for your better safeguard. Otherwise, there is no need. In my humble view, if anyone has a different view, or will quickly move to another question. After commencement of voluntary liquidation, what resolution board of directors or shareholders or creditors can pass which would be binding on the liquidator? Manoj Kumar ji पूछते हैं ये. After commencement of voluntary liquidation, what resolution board of director or shareholder or creditor can pass which would be binding on the liquidator?
Well,
I think board gets suspended, shareholders get
No, Vishal, board doesn't get suspended in voluntary liquidation.
Sorry, powers are vested with the voluntary liquidator.
So, Sudhaji?
Except for the replacement by the members, they should not pass any resolution. I don't see what purpose they should file. Because the business is stopped, there's no commercial transaction happening. It's just a liquidation.
मधुसूदन सर, जो क्वेश्चन है ना हमारा कि हम वॉलंटरी लिक्विडेशन विड्रॉवल के लिए ए के पास जाएं कि नहीं जाएं, एक्चुअली ये इसी में लाई करता है. इस जो क्वेश्चन मैंने पूछा है ना, इसके अंदर लाई करता है. आप ठीक है, आप डिसीजन ले लीजिए, लेकिन आपको अथॉरिटी जब तक अप्रूव नहीं करेगी, लिक्विडेटर कैसे विड्रॉ करेगा अपने आप को वहां से?
इसीलिए तो अमेंडमेंट प्रपोज कर रहे हैं, बिकॉज इट वाज साइलेंट एंड number of cases which have been decided by High Court and Supreme Court in the erstwhile Companies Act, they said the voluntary process has been started by the company, so they can stop it. There is no need of
no, until there is a stamp of the adjudicating authority. We cannot say that this bare filing of the report to the adjudicating authority will suffice the withdrawal.
So from this proposed amendment also it is clear, and from the earlier amendment done for replacement of liquidator, that the board can still take a decision, say the shareholders can take a decision either to replace the voluntary liquidator or to stop the process. Of course, that is another thing, whether the stamp of adjudicating authority is required or not, but that remains still within the power of the shareholders to take a decision. Vishal, can you quickly last question?
Last question. Under which regulation report of ROC is required? ROC himself is asking for that. Any view on that? Under
ROC
which provision or regulation the ROC is required this report?
ROC does not ask any report.
No, which report Anuradha ji is mentioning?
Sir, when we filed the dissolution application under section 59 with NCLT, it is asking for ROC report and NOC from income tax. NOC from income tax, we are still
Okay.
getting it, but ROC is asking under which regulation am I supposed to give you the report?
No, there is no requirement
There is a requirement. At least in Telangana, there is a requirement. My NCLT application is pending for last 2 months only because ROC is not giving the report. The hearing is on and on, 3 hearings.
Then मैडम आपको adjudicating authority का order ही दीजिए कि भी adjudicating authority is asking for that.
सर वो 2 बार दे चुके हैं, उसके बावजूद वो मुझे पूछते हैं कि कौन से रेगुलेशन में मुझे बताओ बोलते हैं.
I think you should refer the matter to IBBI for taking up either in the regulations or taking up with the government authorities. They can
Yes,
take
sir.
Yes.
And I would like to hand over the proceeding to Aanchal for the vote of thanks.
Thank you, sir. After lucid discussion, I appreciate all the participants, all the members, and thank you, Mr. Pranav Damania ji, Mrs. Sudha ma'am, Mr. Raj Kamal ji, Mr. Amit Sharma ji, for sharing their experience for benefit for all. And thanks, Mr. Madhusudan Sharma ji, for convening this interactive webinar. Also, the co-conveners, I'll also thank Mr. IP and Advocate Mr. Vishal Agarwal ji, Vinod Chaurasia ji, Alok Kaushik ji, Manish Gupta ji, and Manish Paliwal ji. And also thank Bank Office Support Mr. Varun for helping me to convene this webinar so successfully. Thank you all. And now at the last. Yeah.
Thanks to Aanchal also for organizing or moderating this. Anyway, thanks to everyone.
Now we will conclude.
Last ritual is required is to be national anthem. We request all of the members to to stand up from at their own place or to join us at national anthem.
Okay. Thank you.
Thank you, everybody.
Thank you to everyone.
Thanks everyone, and particularly Sudhaji, Pranavji, and Amitji for making it convenient to attend and for the whole 2 hours purpose. And let's hope that we participate in more such meetings and seek your cooperation for that.
Thank you for the opportunity.
Thank you. Thank you for inviting. Thank you.
Thanks.
Thank you.
Thank you.